Success in the modern adult industry requires constant hyper-visibility. Maintaining intimate imagery and managing digital interactions is a mandatory part of the business model, but that necessary digital footprint creates a massive surface area for abuse. Former partners, disgruntled ex-clients, or entirely anonymous trolls routinely weaponize that visibility against creators. This abuse usually takes three distinct forms: doxing your real legal identity, uploading non-consensual revenge porn, or coordinating campaigns of damaging reviews. When this happens, many victims freeze. There is a pervasive societal myth that if you choose to commercialize your sexuality, you forfeit your right to complain about harassment. The implication is that you asked for it. Major tech platforms reinforce this. When you report targeted abuse, algorithms and content moderators frequently dismiss it, treating severe harassment as an acceptable risk of the job for sex workers.
Feeling highly exposed online, however, does not mean you are legally defenseless. The courts view your rights very differently than a social media moderator does. The UK High Court actively rejects the idea that abuse is just an occupational hazard for adult creators. We see this clearly in the landmark case GYH versus Persons Unknown. The claimant was a transgender escort facing a severe online harassment campaign. Trolls were tagging her work name in extreme pornographic videos and posting false claims about her mental health and STI status. This diagram shows a legal framework known as zonal privacy. It illustrates exactly how the law separates your public business from your private life. Looking at the commercial persona zone, this includes the information you intentionally broadcast to operate your business. Your advertising rates, your booking availability, and the promotional imagery you voluntarily share live here. But notice the protected private life zone. This strictly contains your legal identity, your private relationships, and your personal medical data. Choosing to advertise sexual services does not drag these protected elements into the public domain. In the GYH case, the judge ruled that publishing intimate details or false health claims about a sex worker's private zone is a legal breach. The court stated it is not fair consumer commentary. Advertising sexual services online does not erase your human right to privacy, and it certainly doesn't strip away your legal protection from targeted harassment. To stop ongoing online abuse, the highest-tier legal response is a formal privacy and harassment injunction. A successful injunction achieves two immediate things. It forces the legal removal of intimate imagery, and it imposes a strict court order barring the individual from ever contacting you again. Many victims hesitate here. The assumption is that filing a lawsuit means your real legal name, your address, and your profession will be exposed in public court records for anyone to find. To prevent that, internet lawyers utilize an anonymity order. This is a specific legal tool that entirely shields your identity from the press and the public. Securing this protection requires a trade-off. You need the emotional stamina to document the abuse, and you need the financial capacity to hire specialist media lawyers to litigate the case. You have to weigh that effort against the cost of doing nothing. Unaddressed harassment damages your business revenue, alienates safe clients, and steadily degrades your mental stability. You can wield the full, devastating power of the High Court against a harasser while remaining a complete ghost to the general public. The next hurdle is identification. Most harassers use sophisticated digital anonymity, like burner accounts and VPNs, assuming they can evade detection. The specific legal mechanism used to pierce that veil is called a Norwich Pharmacal order. This flowchart illustrates how the order functions. The court legally compels tech platforms to hand over back-end user data. Through this process, we recover the precise details hiding behind the screen, including login locations, billing addresses, and phone numbers. If forensic tracing hits a dead end, the court still provides a path forward. We can serve the harassment injunction directly to the anonymous digital profile itself, classifying the defendant as a person unknown. Executing this requires specialized digital forensic legal work that standard criminal lawyers simply do not handle, and navigating these disclosure orders will extend the timeline of your case. Digital anonymity is a temporary barrier. The right legal instrument provides the means to identify the individual behind the screen. Adult review websites present a unique threat. Vindictive clients frequently use these forums to post false claims about a worker's hygiene, practices, or STI status. When confronted, the harasser's standard legal defense is to claim their reviews are protected under Article 10 of the Human Rights Act. They argue it is freedom of expression or consumer advice. The High Court explicitly rejects this defense. There is zero legitimate public interest in distributing false health information to harass a sex worker. When health claims are fabricated, the harasser's right to free speech is entirely overridden by your Article 8 right to privacy. The trade-off here is that you must be willing to confidentially share your accurate private health records with your legal team. You have to definitively prove to the court that the online claims are lies. Once that proof is established, the court forces the immediate deletion of the defamatory reviews and heavily penalizes the poster. The law prioritizes your physical safety and objective truth far above a troll's assumed right to spread malicious fiction.
This quadrant chart maps out the effort versus the impact of your options. Simply clicking report on a social platform is low effort, but it yields almost zero impact. A high court injunction is high effort, but it delivers a definitive, legally enforceable result. This legal path is built specifically for creators facing sustained multi-platform harassment that is actively destroying their mental health and financial income. If you are looking for a free, overnight, do-it-yourself fix, this is not the right approach. These are precision legal instruments, requiring dedicated funding and time. The law strictly separates your commercial adult services from your private human rights. You do not have to endure abuse simply to exist and work online. Cohen Davis solicitors are specialist internet lawyers who litigate exclusively to protect digital safety. We provide non-judgmental advice and robust representation, regardless of our client's profession. Call our free 0800 helpline to begin building your confidential legal shield today.